judge. I didn't know who he was at the time. Judge Wells told me that later. And so, because I'm accusing leaders of crime, Judge Wells thought maybe it was appropriate for Mr. Leaders to leave the courtroom. And she asked what I thought, and I said, I have no problem. I mean, obviously, I don't have any problem telling him to his face, because I was convinced he did these crimes. And so he could stay. And so the judge asked me some questions. He answered, and he wanted to speak first, so he did it on the phone as a Skidmore. And then when he was done, I spoke my piece, and Mr. Skidmore told me that I was wrong in understanding the rules of the law, and that I should give him the information. And Judge Wells believed he was correct. She also said that this was the first time she ever had a grand jury do this process, so she wasn't familiar with it. But again, going back to that process that I developed, we could have done something before that particular day.
Is this a criminal grand jury?
Yeah.
So they swept it under the rug?
Yeah. Well, you can define it any way you want it. You know, my point was, I don't care about the venue. I don't care. If they were wise, they would have said, okay, well, you can give it to the grand jury, because then I couldn't be speaking publicly, because the information I give to the grand jury is private information. I can't go public. Plus, the process of the grand jury is, I have to, the report that you have is, I was going to present that to the jury, present my evidence, and have them vote on that. And as I told Judge Wells, if they voted against it, it would be done. If they voted for it, all we would be doing is putting out a report. When you put out a report in the grand jury, those that are named in the report have an opportunity to respond to the report. And so then the judge is obligated, once that report is submitted and it's done properly, and the people that are accused in the report have responded, then she puts it out to the community. It would have taken months, if not years, for that process to be accomplished if the grand jury had agreed. But they said no. I said, okay, I have no problem with that, because it doesn't matter, because I'm going to still get it out to the people. And then, like I said earlier, you guys have to decide what we're going to do. And I'm going to go and talk a little bit about the Department of Justice at the federal level, because it's just as bad in the DOJ in Anchorage. And so what ends up happening is people have told me, Ray, you need to go to the DOJ and claim a whistleblower for their protection. Protection to the DOJ? Let's look at Joseph Botini. Joseph Botini, I'm going to go quick, I think. Joseph Botini is a prosecutor up in Anchorage. He was the most disciplined attorney, we think disciplined attorney, on the Ted Stevens case. Now, I didn't know this at the particular time, but a book came out after his exposure, after the corruption was exposed in the Stevens case, and one of his attorneys wrote this book, and I went down to my local bookstore and bought it. And I told the person, this is a great book, I want to read it, will you get it for me? Sure, we can get it. Wow, this is a great book. Alaskans everywhere need to read this. I'm going to get some extra copies. I never heard back from him. I stopped in the bookstore a few weeks later. What about that book you were going to order? And get copies for other people to buy. My distributor doesn't handle that book. You should try going through Amazon. Well, I buy all my books through Amazon now because I'm not going back to that bookstore. The book gave me a word called exculpatory evidence. It's evidence that might be beneficial to the defense. And so what was exposed in this report, this gets back to why I believe we should get Henry Schaeffer III here to lead this grand jury, and David and I disagree a little bit. He thinks the grand jury can investigate. The time commitment to investigate the corruption in Alaska is so extensive, the grand jury is not going to be able to accomplish it because it'll be a full-time job, and who's got to, I mean, we're going to get all these old guys that are retired to do the investigation. But Henry Schaeffer, you'll volunteer, or one of the old girls. And so So he investigated, I think it took him 2 years to investigate the crime of Ted Stevens' unlawful conviction. And he wrote a report, 525 pages of this report. And so in that report, he talks about Joseph Botini as being one of the in fact, he was the most mentioned, the most punished, not really, but supposedly punished in that. So this is his letter. He's saying, here you go, Judge, here's the report. Now the judge keeps it secret for a while. And finally the judge decides who will let this out to the public.
Was that Emmett Sullivan?
Yes. Yes, it is Emmett Sullivan. He's Washington, D.C., I think.
He's got a great track record.
Does he?
Yeah.
Okay. So Emmett Sullivan looks at this thing and says, we're going to let it out, and we're not going to put any redacted. We're not going to remove anybody's name in it. Now, when Sullivan, Schulke, originally made the report, he said to all those people that are accused, just like the grand jury, we're going to put this report up. Do you want to say anything? They said, no, we don't care. Because the judge is the only one that's going to read it. Well, when the judge said, I'm making it public, guess what? Everybody, and David said, lawyered up. And, they ended up responding to it. But anyway, that's the report. So what I would encourage everyone to do is to get online and look at Henry Schulke. And again, what I'm trying to show here is the power. This guy is a no-nonsense guy. He calls it the way he sees it. And if we had him investigating here, he doesn't care who's out there, how powerful you are. He will get down. This was an interview. He ended up, after it went public, the Senate then calls him into Senate hearings, and there's a hearing that's like an hour and a half. And if you just go Senate hearing, Schulke, it'll pop up. But I wanted to show you.
As a matter of fact, at one point during that colloquy on September the 10th, Judge Sullivan said, well, so what should I do, Madam Prosecutor, addressing Brenda Morris? Should I issue an order that you produce any and all Brady and Giglio material? And the response was, if that's what the court wishes to do, the court may do so. The court, however, concluded that colloquy on September the 10th by saying, I am not going to issue an order. I will accept the professions of good faith on the part of the government. We all know the law. They tell me they know the law. There is no need for me to issue an order compelling them to comply with the law. Hints to the wise should be sufficient.
As a result of this case and going forward, should all district judges issue formal orders to DOJ prosecutors instead instructing them to comply with Brady and Giglio in an effort to ensure compliance and secure the possibility of criminal contempt?
Well, Senator Grassley, that's one way to address the issue. I'm not satisfied that it is the best way to address the issue. I say in the report, during the discussion of whether or not Judge Sullivan had issued an order, that no district judge ought to be required to order prosecutors to comply with their constitutional obligations, let alone be required to issue an order so specific that it might support a criminal contempt prosecution in anticipation of its willful violation. That doesn't make any sense to me. It is true that around the country, at last count of which I'm aware, some 38 of the 94 districts have standing local rules which order the production of Brady and Giglio material pre-trial as a part of the overall discovery regimen. That's one way to address it. There are judges individually who have standing orders in every criminal case to the same effect. And indeed,
I think you've answered my question. Let me go on to another question.
yes, sir.
So this had to do with the exculpatory evidence, and I'm going to show some of that in a minute. The exculpatory evidence is evidence, again, that will show that the defense may very well be telling the truth. Okay, and so that's where the Botini and Gakey in Alaska withheld this exculpatory evidence. And the discussion here is, should the federal judges start ordering every one of these district attorneys, you have to give exculpatory evidence? In the Stevens case, the defense kept saying, they're not giving us everything, they're not giving us everything. And the prosecution says, well, we're going to get it to them. Yeah, we'll get it to them. And that was what the judge, what Schaeffer was just talking about, was this dialogue between the prosecution and the judge. And the judge says, are you going to give it to them? Well, yeah, we've been saying that for an umpteen number of months. Well, what do I have to order you? Because if you order the prosecution to give the exculpatory evidence and they don't, now it's contempt of court. Botini was never criminalized for what he did because the judge never gave the order. And that was the dialogue that you just heard. Now, Mr. Schulke and I disagree on whether all judges should be ordering it. And just so you know, in the state of New York, because this exculpatory issue is a national problem, a state problem, because prosecutors can withhold it, or they dump in, a terabyte of documents, and somewhere in there is that exculpatory evidence. So last November, this Chief Justice of the Supreme Court in the New York, state of New York, issued an order starting January of this year that every judge on criminal cases are to order the prosecution to give over exculpatory evidence. The Chief Justice ordered all judges at the state level to order the prosecution to give over exculpatory evidence. And the reason they did that is because now if they don't do it, it's going to be a contempt of court charge.
One of those prosecutors was so embarrassed by that 525-page report.
Nick Marsh, he committed suicide. Nick Marsh, though, in his defense, and this is my belief, Nick Marsh was 37 years old. Botini and Gakey were in their 50s. Marsh was over his head, and he wanted to win this case because it would be a real notch, of winning something. So he believed what everybody was telling him. These older, more experienced attorneys.
You are morals in kindergarten.
Well, and again, I'm not sure about Nick Marsh, so I don't take him, but he did hang himself.
And our prosecutors for years here, I can't remember her name, Old Troll.
Let's continue on, because here is what this senator believes we have in this country.
This is an area, Mr. Schulke, that we've had a great deal of interest in, as you can imagine, senators of both parties have talked to me about this. I've said many times, in a lot of different contexts, our criminal justice system is the envy of the world. Our constitutional framework provides that all individuals are guaranteed the right to fair treatment, a fair trial. But in order for our criminal justice system to work, the courts must ensure adherence to the rule of law. Defendants have to be afforded vigorous and competent counsel. But I feel, and I think Senator Cornyn, who's a former prosecutor, also would agree, prosecutors bear a very special responsibility in the system. They wield so much power when it comes to charging decisions, not only to bring a charge, but also determining when to withhold a charge, plea bargaining, trial. Prosecutors have to uphold the law. They have to adhere to the highest ethical standards. They have to seek justice. The integrity of our criminal justice system relies heavily on prosecutors, on the fact that they want to make sure all parties, the state, defendant, witnesses, victims, whatever else, have to be treated fairly.
So there's two things that end up happening. There's a couple things that end up happening at our Senate level. Lisa Murkowski is upset because of the Schulke report. The Schulke report states that Gakey and Botini deliberately, intentionally withheld evidence. Now, the Dan Sullivan had a different approach to going, thank you, David. But here, Senator Murkowski's press release of 12, she talks about, and let me just flip through it. Basically, she says, so there's the investigation, the Schaeffer investigation. There's also an investigation in the Department of Justice. The Department of Justice comes to the conclusion that it was an unintentional mistake, where Schaeffer says, no, it was intentional. Lisa Murkowski's upset because they only got punished 40 days suspension without pay for Volpini and 15 for Goki. And remember, these are Alaskan attorneys in Anchorage, Alaska, even though this case took place in Washington, D.C. So she's upset because they're not getting bad enough punishment. And she talks about how this is the worst case in 200 years of history. And again, what she says here, down the middle here, rather than speak to the possibility of a larger, more systemic problem inside the Justice Department, the Office of Professional Responsibility wants us to believe that this was an inadvertent error of two lone actors. She continues, I remain unconvinced. So Dan Sullivan has a different approach. Dan Sullivan's our current senator. Dan Sullivan, when this was all kind of going down, and I think even before that, he was our Attorney General. Now, he wanted to go after Bill Allen. A lot of the exculpatory evidence against would contradict Bill Allen's testimony, because it was really, he was the primary witness. And so Sullivan knew that Allen had been having sexual relations with a 15-year-old that came in from Washington State, I believe. The Anchorage Police Department had investigated it. He felt it would be prosecuted, but the DOJ wouldn't give him or wouldn't prosecute it. They kicked it out. So that was when he was the Attorney General. He then becomes senator. He's elected in November of 14, and this was his press release as of March of 16, March of 15. So within 3 months, he was sworn in January. In March, he puts an amendment to a human trafficking bill. And what the amendment says is, and he presented it wonderfully, you can see it online. He said, listen, senators, we really need this because the federal government's financial stress, and us states, we can help them out by getting their permission to prosecute criminals that have broken federal law, but we can be kind of a sub-agent of the federal government. And so he introduces that bill because the law that Bill Allen broke was the Mann Act, which says you can't bring underage prostitutes across the state lines. So he was trying a way to get in to prosecute Bill Allen. So he puts out this press release saying he introduced it. He then says it passes the Senate. It passed 99 to 0, because apparently there was one senator that wasn't there that day. Okay. And then he decides to talk to the Attorney General, who also, then they put out a press release. They said, this is it. We're going to go after Bill Allen. We got Senator Sullivan that believes Bill Allen can be proven to be guilty. We've got the current Attorney General, Craig Richards, that believes it. And we have the Anchorage Police Department that believes it. But they have to get the permission from the Department of Justice. And so the next press release, 4/5 of 16, he reacts to the DOJ's decision to deny the investigation of Bill Allen. And so I find it incredibly frustrating that it took the threat of violating a new federal law for the Department of Justice to finally and directly answer a question that Alaskans have been asking for years. There was ample evidence in this case to allow the state to investigate and prosecute Bill Allen. But the Attorney General of the United States is saying that doing so would undermine the administration of justice, claiming that because the DOJ previously decided not to cross-designate the state, the DOJ was required to deny the state again. Such circular reasoning obscures what this case was all about. Now, so we got The Alaska Police Department believes there's enough information. We have the current Attorney General believes there's enough documentation. We have. He's now Senator Sullivan, still believes it. Well, let's see what Mr. Schulte thinks about this.
I understand that attorneys for Mr. Bottini, the Assistant U.S. Attorney handling the case in Alaska, said he pressed his supervisor on 7 separate occasions to voluntarily disclose impeachment information regarding the possible subordination and perjury by Bill Allen, who was a key government witness, he said. And the other line prosecutor in Alaska, Mr. Gecki, he claimed they moved to disclose that, but your report says that Mr. Bottini and Mr. Gecki intentionally withheld this information and does not and did not try to get it disclosed. So which is which is it? Did they attempt to get their supervisors to disclose information by Bill Allen, or are they not being truthful when they say that on these numerous occasions they asked to have it?
As our report indicates in great, some would say excruciating detail, Messrs. Bottini and Gecki on a number of occasions proposed, indeed urged, the rest of the prosecution team that some disclosure be made about evidence which was in their possession indicating that their star witness, Bill Allen, had suborned a false statement from a young woman who was a crack-addicted prostitute with whom she claimed to have had sex when she was 15 years old.
And this exculpatory information was not made available?
It was not.
Thank you. Senator Grassley.
So that basically was the information that there was sex with this minor, and that the jury knew that about Bill Allen, that the credibility was going on the truth. Plus, there was a lot of other things that went on. But my point here is that we've got 2 lawyers who were Attorney General. One of them is now a senator. We've got Schulte, who's talking about the same thing because Bill Allen convinced Bambi Tyree to lie in an affidavit about sex with Bill Allen. She lied about that. That's what he just said. And so we also have the Anchorage Police Department. But here's a letter to Craig Richards denying Alaska to go after Bill Allen. And basically it's just the department undertook a serious investigation into the allegations concerning Mr. Allen. And again, she says, I think she should be Bill Allen's defense attorney and let the state and a jury prosecute it. And of course now it's so long, it's not going to matter. But my point is the Department of Justice can't be trusted. So let's go back to the quote from Senator Murkowski. And again, she's upset, but she's talking about at least they're getting a 40 and a 15-day suspension without pay. Well, here's what we know about Bottini. He has been an expert attorney within the Department of Justice since his novice entry in '85. He continues to prosecute for the Department of Justice in Alaska. His punishment for his bad behavior in the Stevens case was a 40-day suspension without pay. It was the worst punishment the Department of Justice doled out in the corrupt conviction of Senator Ted Stevens. However, Mr. Bottini and Mr. Goki appealed the ruling to an administrative law judge. Now, the administrative law judge looked at the evidence and said, well, my only job is to look at the evidence about the punishment. I didn't look at the evidence of their behavior, and my evidence shows that the Department of Justice failed to give Bottini and Gecki due process. So therefore, their 40-day suspension and 15-day suspension became a paid vacation. And on top of that, the judge said, well, these guys shouldn't have to pay for their attorneys. So you taxpayers pay for their attorneys. And I understand their attorneys were making somewhere in the neighborhood of $500 an hour. Pretty sweet deal. So their punishment became paid vacation. I'll continue. It helps to develop the case against Senator Stevens, well documented. He being Bottini intentionally withheld evidence. He also, Bottini, was also principal architect in the development of the case against my friend Schaeffer Cox, the militia leader. He was also developed in the case against legislator Peter Cott and Richard Corning, and Mr. Philip Holmick, who was their attorney, is now Mr. Cox's attorney, and he was able to get their rulings overturned. But then we have an associate with Mr. Bottini. It is Stephen Strachey. Our two attorneys working with the Department of Justice in Anchorage, working side by side for 27 years. According to Strachey, previously posted resume, he has worked in the Department of Justice since '91. All those years in the Anchorage office, one of the three departments of justice in Alaska. Bottini, too, had worked in the Anchorage office since '85. Bottini and Strachey worked on the Schaeffer Cox case together. I imagine they worked closely over their entire legal career, both of which have been completely within the Department of Justice Anchorage office. Like all professionals who work together, we know the processes others use in our related field. In chapter 24 of Bob Terry's book, Not Guilty, the Unlawful Prosecution of Ted Stevens, it states the Department of Justice published a series of memos addressing concerns about the Department discovery practices and emphasizing that federal prosecutors would receive increasing training. Are we to believe the corrupt conviction of Ted Stevens was because of ineptness from all those involved? Kerry goes on to say, 96% of federal criminal cases are resolved by plea bargains. So the Brady rule, that exculpatory evidence rule, puts defendants at a disadvantage in negotiating without access to the information within the government files. This becomes important in those cases where the accused demand a trial. It is why the senior attorneys in the Department of Justice lie and cheat to get a conviction, where they think they can bully the accused into a plea deal. Not the case with Ted Stevens or my friend Schaeffer Cox. It's important to develop a timeline understanding why Joseph Bottini was dropped from sight on the Schaeffer Cox case. I am sure Bottini continued behind the case. I start the timeline with the investigation of the corrupt conviction of Ted Stevens at the time when my friend Schaeffer Cox was making a public presentation at a national audience. April 9th, April 7th, 09, Emmett Summer orders the investigation. Schaeffer Cox involved with a militia patriot group called the Third Continental Congress. He's elected from Alaska to attend. He gets notoriety. He's a dynamic speaker. March 11th, Schaeffer Cox is arrested. March 17th, the indictment against Schaeffer Cox. Joseph Bottini is the first Department of Justice attorney mentioned in the indictment. He's on the list of every document. Joseph Bottini, May 11th, May 4th, 2011. Notice of attorney appearance, a legal document filed in court stating he is co-counsel for the United States of America in the Schaeffer Cox case. November of 2011, Schaeffer report exposing the corrupt behavior of Joseph Bottini is presented to Judge Emmett Sullivan. Not to the public, documentation is for the judges only. February 2012, from Cox indictment to this date, there are several documents filed in the court dealing with Cox's case. Everyone mentions Joseph Bottini as a co-counsel. However, this was the last time Joseph Bottini is ever mentioned in the Cox case. I am sure he continued to direct the case outside public view. It has been reported he whispered directions to Strachey during Cox's trial. He was an integral part in bringing charges against Schaeffer. March 12th, Judge Sullivan allows the public release of a complete choking report. Amazing. Nothing redacted. Showing all the names and information, including a Joseph W. Bottini. March 2012. Another legal document filed in the U.S. District Court. It is the first time Joseph W. Bottini is not mentioned in the Department of Justice filings in the Cox case. The Department of Justice did not want Joseph W. Bottini exposed in the Cox case. April 2012. As reported in the ADN, just this last January, the FBI asked the Department of Corrections to audio record a visiting room where a defendant by the name of Israel Keys was being held. And this was all without a court order. I understand it was the same room that Schaeffer Cox used with his private conversations at the same time. Somehow the recordings, the illegal recordings between clients and their attorneys, somehow those recordings were left to run for 4 years before they found out. And again, this was just in a January article. August 2017, Schaeffer Cox has an appellate court hearing. Now, during Schaeffer's conviction the primary issue was a conspiracy to murder and a solicitation to murder. Two separate situations. The solicitation charge had to do with a meeting he was having at a King James radio radio station in North Pole, Alaska. He had heard that OCS was going to have the state troopers come in to take his child. He had also heard from a reliable source that the federal government had a hit team that was going to assassinate him. Right or wrong, he got it from what he thought was a reliable source. So nothing happens at the radio station, but he talked to his fellow militia member that said, if somebody comes in to kill us, we have to defend ourselves. That's what he explained. Well, the state said, no, that was a solicitation. He was wanting those individuals to kill people, and basically he was not hiring them, but soliciting that they would do that. The problem was, when it came to the trial, the problem with that is the government said, we didn't have a hit team. There was no hit team. So during Philip Polnick's argument before the appeals court last August, this is what the judges had to say to Skoraki. Remember, Bottini's in the background. He can't be out in the public yet, even last summer. We're letting Skoraki go ahead and handle the case. So Skoraki had pushed this information, the solicitation, through the judge to get the judge to let it enter and got the jury to convict it. Now, this is what the appellate court judges say to Skoraki, and listen to his response.
I get your point about some of the other aspects of the conspiracy, but can you cite me or the panel to any case that have facts analogous to this on the solicitation to commit murder?
I think if we would have found it, we would have provided it to you.
Exactly. There isn't any such case, is there?
No.
You're effectively asking us either to make new law or conclude there's not sufficient evidence on this point, right?
We would urge that the evidence was sufficient on solicitation, that because it is so clear, this is not a situation of them making this up out of whole cloth. There was a direct intention for them to do that. There was no doubt about it. And if you
also have a direct intention to kill Mickey Mouse, and I go solicit somebody to kill Mickey Mouse, well, there's no Mickey Mouse to kill. Can you still have a solicitation? You could have a conspiracy that's impossible. Can you have a solicitation that's impossible?
I haven't found a case that says you can't.
And so Skoraki failed. The appellate court decided that they would throw out the conspiracy, and now it's supposed to go back for resentencing. However, the way that the conspiracy and the solicitation were connected together, it's probably not going to really make any difference on that. But what's happened now is Philip Kovic, his attorney, appealed it back to the appellate court and said, listen, you guys, you got this wrong. Will you reconsider it? And of course, they said no to that, and we're going to talk about it going to the Supreme Court here in a minute. let me go back. It's my belief both Teeny and Scrocky are two such attorneys withholding exculpatory evidence, both working for the Department of Justice in Anchorage, working side by side for 20 years. According to Scrocky and previously posted resume, he has worked in the department. I've already talked to that. And I guess what I haven't mentioned yet. Scrocky now wants to, and he used this trial of Schaeffer Cox to put on his resume because he wants to become a federal judge. And I've written letters to both Murkowski and Sullivan about that, and Sullivan did respond and said that he would consider, I'm asking them to vote against Scrocky becoming a federal judge here.
And what about Scott Leeds when he's being judge here?
Yes, that's another issue. And thank you for doing that. I didn't bring that up. But Scott Leeds has applied for the Superior District. I forget now, but he has applied for a district court or superior court here on the Kenai Peninsula.
Superior Court.
Is it superior?
He still has Moines Fallon. We got to get that as too.
Yeah, and again, we can, what we need to do is truly investigate. We don't have a governing agency that truly investigates. Let me just skip through this. So this was a newspaper article that just came out last Sunday regarding Schaeffer Cox. And basically what it says is, Philip Holmick now has appealed the case to the Supreme Court. Now, in that appeal, it's like 1 in a million chance to get to the appeal to the Supreme Court. However, there's some interest now because of Philip Holmick's approach. I don't know whether I put this in here or not. But what he says is there's a conflict because in order to have a conspiracy, doesn't there have to actually be a time and place? Philip Holmick talks about a book that was written where two guys decide that they're gonna, if they win the lottery, they're gonna kill their wives. Book, fiction. And so the argument in the book is, can it be a conspiracy because they haven't won the lottery yet? And Schaeffer was preparing for an economic disintegration, as I continue to do so today, because of the economic situation in the country and the world. And so he was concerned about a dictatorship, a Stalinistic, as Philip Holmick said, in the appeals, that if that happened, if they started arresting people, locking people up, then he would fight. And he would fight to keep that from happening. That's the conspiracy that they convicted him of. The problem with it, and Philip Holmick isn't going there yet, but part of the problem is the exculpatory evidence. And I don't know what a terabyte is, but it's like this massive amount of electronic information. And so the federal government gave him all this information, and Schaeffer's got a public defender who can't possibly go through there and find exculpatory evidence. Now, Schaeffer did file a lawsuit against the Department of Justice. And what he did is he's asked for exculpatory evidence, and he's starting to get it. Now, under the Freedom of Information Act, he wanted to get that. They said, absolutely not. We're not going to get it. So he sued, he won the case, and now the federal government is going to give him something like 2,735 documents. But they can only review 500 a month, so he's going to get 500. Well, they're starting to trickle in. And so let's look at some exculpatory evidence. And I've got these documents with me. You can't see it here. This is one. Now, according to Prosecutor Scrocky, there were only 2 federal informants that were keeping an eye on the militia or Schaeffer Cox. Well, this is a document that counters that. There was actually 4 FBI informants. And what ends up happening in his defense, in Schaeffer's defense, is that it was the FBI informants that were instigating and trying to generate things. And in fact, Schaeffer talked to troopers, Ron Wall, and Rex Leaf about that, because he was afraid that there was going to be some crazy militia guy, one of them being a guy named Bill Fulton.
He tried to throw these flashbang grenades, and that's documented.
Well, and again, Bill Fulton is the FBI informant who is running crazy in the militia. Schaeffer now realizes this guy's a loose cannon. I got to let the police know this. So he actually contacts Rex Leakey, he contacts with Ron Wall, I think, and I got a little bit of document here. But what happens is because the exculpatory evidence isn't given to Schaeffer's defense, they no longer can show that what Schaeffer is saying is true. So we know there was 4 elements, or 4 FBI informants. Here's a document that I got earlier this month, and it's a document that Schaeffer received, and it was redacted, but this is a report of an FBI report about a conversation that Lieutenant, I think it's Ron Wall, was now captain, but he was a lieutenant in Fairbanks. He's now the captain and in charge of it. But this was a discussion that the trooper had with the FBI. This was a document. So when Schaeffer got it, he put in the blank spots because he was there. In the testimony, Mr. Wall, Trooper Wall, talks about how frightened he was when Schaeffer shows up at his house with his wife, to talk about the fear that he was having about these crazy guys by the name of Bennett and Fulton. Now, we don't know whether Bennett was an FBI. Schaeffer thinks he was. Certainly there were 2 that we don't know of, so maybe he was, but they were talking crazy things, and he was concerned about the community safety, so he was sharing that with Ron Wall, with Schaeffer's wife there. And the reason I know that, because again, Schaeffer put all this in, and I've got contacts that send me information. I don't have any direct contact with him. So he's still in the information, and his wife is there. Well, what I did is I took that information and looked at the testimony from the transcript, Ron Wall's testimony. Now, Ron Wall never mentions that Schaeffer's wife's there in his testimony, but the prosecutor does mention that Schaeffer's wife was there too, wasn't she? He says, yeah. And he goes on in great detail about how frightened he was about him, but he invites him in the home, and they sit down and talk, and Schaeffer talks about the fear that he's having with these guys. And the testimony Trooper Wall gives is that he was frightened, but he let Schaeffer in his house. Schaeffer's, or Mr. Wall's children are upstairs, upstairs, that was me. And so all of that is exposed in the courthouse, in the court record. So what I wanted to do today was get a hold of his wife, Marty. Marty, were you there? What did you see? Did you hear him mention Fulton and Bennett? Because Trooper Wall never did that. I wanted to know. But of course, I didn't want Schaeffer to know that I was trying to get the number from his wife to talk to her. Well, I got the word from him. He wrote a letter to my contact who said, I don't know who's trying to get a hold of my wife, but please don't. She's scared to death. He called it the gangster state that's out there. And she is so frightened, she didn't even give testimony at his trial because she's so frightened of what kind of a judicial system we have in the country. He said that if you get her number and you call her, she's going to change her number, and I'm not going to get it, and I won't be able to be in contact with my children again. So one last thing that I want to say, and again, here's the report. Get online and do some research on the prison that Schaeffer's in. It's called a Communications Management Unit, CMU. There was a great speaker who spoke to, there's an organization called TED, T-E-D. Does anyone know that organization? This was a reporter that investigated these communication management units. There's only 2 in the country. They are mostly for, I believe, political prisoners. They call them terrorists. And they limit, and Schaeffer says it's torture. Now, I don't know whether that's physical or mental, but this reporter was the only reporter that's been allowed in there. These jails, these prisons are not reviewed by any government agency. They're kind of rolled on their own. And This reporter that got in and did this investigation, and he's on the TED talking about the CMUs in the country, he is then put on a government watch list because he's talking the truth. But you can find that, look up CMUs and look up that TED organization. I thank you for putting up with me for all this time. What I want to do, and David wanted to spend some time talking about the grand jury, and I'm going to rest.
Did Bolton ever surface?
Bolton actually wrote a book.
He did.
Oh man, it's just a wonderful. He bragged about his badassery, was the title of the book. How his badassery took down the militia.
What's the title of the book?
Ray, can I ask you one thing? How many signatures are we going to need to get this thing going?
No idea. I don't believe signatures are going to do it. You had Senator McChickey here.
Yeah.
Every one of us had 10 people calling him and saying, we don't want a government agency. We want a grand jury investigation. We need a good leader outside of Alaska. Because what they're going to do is exactly what they did with Tammy Wilson. They're going to say, okay, we'll give it the grand jury. The grand jury says, this is going to take me a year, 2 years. No, I don't know. Let's have the ombudsman do it. The ombudsman runs a report and says there's unlawful activity in OCS. Okay, thank you. Oh, got it.
I've written a couple letters to Trump recently, and I'm trying.
Well, again, we have to look at it outside the federal government structure. We're adults. We are Alaskans. We don't need Washington's help. We can do it here in Alaska, and that's what I want to do.
We don't need our lawyers here. I've tried 17 of them to take and even help me get on one thing just to subpoena. As soon as I talk to Citizen Lindquist, it's a federal attorney.
David, why don't you come on and talk about the grand jury, because that's really what's got to happen in my mind. Because all the rest of it is just talking. We have to get the grand jury.
Sir, if I could ask you a quick question on CMUs. You know,
well, look at the question. That thing you're speaking okay. Any question. I need something good.
Yeah, he made a long time, yeah.
Everybody is right here that there isn't a really good procedure to require an investigation. But there is only one. It's an individual grand juror has a right and a duty to inform other grand juries who then have a duty to investigate. And I've put a lot of time and effort into what's went on here, 14 years. And without any doubt whatsoever, the grand jury is our best hope to actually get something done. And so what I want everybody to do, there's very little documentation on what's called an investigative grand jury, but they are the same grand jury that sits as a charging grand jury for the prosecutor and troopers. But in the investigative grand jury, they are allowed to investigate on their own anything they want to, as long as it concerns either crimes committed that are triable or that concern the public welfare and safety. And so any grand juror can ask for that to be done. Mr. Southwell tried to, but what I want everyone to do is to make sure that they accept any juror notification, notice for jury duty, that anybody they know that are grand jurors, that you inform them that you want them to bring up to the other grand jurors their belief that there are crimes committed or that there's a public safety and welfare issue, and that they want Mr. Southwell and or I or the witnesses that testified here today to come in and bring their evidence and have the grand jury investigate. That is something that is by law on the books that we can actually do. They're also in this report, and it's called the Investigative Grand Jury in Alaska. It was put out by the Alaska Judicial Council. It says that grand juries in Alaska can be called for by public petition, but there's no number of signatures required. There's very little information on it because it happens so rarely. Rarely does the grand jury on its own decide to investigate. And I want to go over just what was talked about by the people who wrote Alaska's Constitution. In the Constitutional Convention in Alaska, the delegates specifically address what a grand jury is for, but through the years it's been lost, it's been forgotten. Right now, all it is a rubber stamp for Kenai District Attorney Scott Leaders to get indictments to send people to trial. But their real duty is to investigate on their own, but they've forgotten it. And I'm just going to go over some of the evidence that proves that's true. The number one is the Alaska Grand Jury Handbook, and I think Mr. Southwell was given one of these when he was a grand juror. Well, I have someone that's told me they don't no longer, after Mr. Southwell's grand jury experience, they no longer give these out. And this was September 2016, and I want to read on page 17 what it says, because Mr. Southwell wanted to present the evidence and witnesses that you've seen here today to the other jurors. And he was told by District Attorney Scott Leaders he couldn't do so. That was then confirmed by Superior Court Judge Jennifer Wells that he couldn't do for. This is what it says on page 17 of the Alaska Grand Jury Handbook. It says, can a grand juror ask the grand jury to investigate a crime that the district attorney has not presented to them? The answer is yes. The Alaska statute states, if an individual grand juror knows or has reason to believe that a crime has been committed, the juror shall disclose it to the other jurors who shall investigate it.
What's the statute?
That statute, it is Alaska Statute 12.40.040. And I'm going to just go through here quickly. I know everybody wants to leave. A lot of people have left already. Page 25 of the Grand Juror's Handbook. What can the grand jury investigate? It says grand juries have, quote, the power to investigate and make recommendations concerning public welfare or safety. Do you think Mr. Southwell was reasonable to think that there was a public welfare or safety issue for our public when the district attorney is out there falsifying evidence, troopers are committing perjury? The only judge investigator in this state for the last 28 years is falsifying investigations so corrupt judges can continue sitting on the bench. Do you think, does anyone here that's a public concern or for welfare or safety? Yeah. Do you think that that's a concern to you, to the public? Okay, if that's a concern to the public, the grand jury should have investigated it on their own, because those officials are the same ones that normally control the grand jury. Okay, I'm going to go over just some of the things. Page 26, some of the things that the grand jury investigates. Has investigated in Alaska in the past. Not the recent past, but a long time ago, at least according to Alaska standards. The Anchorage Grand Jury investigated the conduct of the Anchorage School District, the Anchorage Police Department, and Anchorage District Attorney's Office relating their investigation of a high school teacher's sexual relationships with students. I don't have a date for that one. Alleged misconduct in state and local government. In 1981 and 1982, separate grand juries in Juneau conducted investigations of alleged misconduct by 2 state senators. In 1984, the Anchorage Grand Jury investigated potentially criminal practices related to property and inventory maintained by the Alaska Division of Fish and Wildlife Protection's aircraft section. Okay, you've heard and seen testimony here that they took my plane illegally and then are now illegally trying to alter the judgment against me to include a corporation that never had a chance to protest to sell an airplane. Another, in 1973-74, a Kenai grand jury considered allegations of improper conduct by municipal officials, including allegedly inappropriate conduct by a judge. So what we're asking, what Mr. Southwell wanted to present to the other jurors is exactly what they're allowed to do. And he was shut down by it. And the law supports that he had a right to do that. Other grand juries have investigated in Alaska the criminal justice system. They've investigated the effectiveness of police operations in Bethel in 1977 and 1983, the operation of the jail in Barrow in 1983 following an escape. Okay, page 27 of the Grand Juror's Handbook. Who decides that the grand jury should investigate something? That's the question in there. It says, generally, grand jury investigations are initiated by the district attorney. They can also be initiated by the presiding judge or by members of the grand jury, except Mr. Southwell.
The judge ordered him not to do trouble.
They forgot to put that in there.
Yeah, she was assigned to my case and recused myself.
Did you hear anything about your case that Ray Southwell brought to her?
Supposedly they didn't know it was about my case, but eventually they did. So you are kind of correct that she should have never actually even been deciding on a grand juror that wanted to bring up issues in my case. But let me just, everybody's going to want to leave here. A lot of people have left already. So anyway, generally grand jury investigations are initiated by the district attorney. This is what's important for all of you. They can also be initiated by the presiding judge or by members of the grand jury, like I said, other than Mr. Southwell. Prosecutors sometimes receive letters from the public addressed to the grand jury requesting investigations. In these situations, a prosecutor will probably conduct a preliminary investigation and make a recommendation to the grand jury about whether to take action. It will be up to the grand jury to decide whether to investigate the matter requested in the letter. How many of you here think if we write 1 billion letters to Scott Leaders will request the grand jury to investigate Scott Leaders? Raise your hand. Okay, that's what we're up against. That's why it was so important when Mr. Southwell had, and I'll just say it, I won't say it, the wherewithal to go in there and in the face of the district attorney and the troopers to want to present evidence of wrongdoing, crimes and other wrongdoing by state officials, including the troopers and district attorneys. I hope everybody here realizes the risk that Mr. Southwell took on my behalf, but more importantly on all of your behalf, that the same thing doesn't happen to you. I'm going to go quickly and go through this report. It's the investigative grand jury in Alaska. It was published February of 1987. It was put out by the Alaska Judicial Council at the request of, I believe, Alaska's Senate at the time. It's interesting to me that one of the people who helped draft this document is Marla N. Greenstein, the same lady who for the last 28 years has investigated every single judge in the state. And I'm just going to go quickly through what this report says about state grand jury investigatory powers. And because there's not a lot of information about how these grand juries work, because they happen so infrequently, they go over what other states have done, examples in other states. And basically what they're saying is, this is what they did in another state, this is what we can do. State grand juries have often exercised investigative powers to battle political corruption. At times they have acted on their own initiative in the face of opposition from a district attorney. What happened to Mr. Southwell? He tried to investigate, and guess who shut him down? The district attorney. They're saying that a grand jury is supposed to act in the face of opposition from the district attorney. They say here, an extensive grand jury probe in New York City, an extensive grand jury probe toppled the notorious boss Tweed and his cronies. Since the district attorney was closely associated with Tweed, the panel acted independently of him, conducting its own investigation and interviewing witnesses without the prosecutor's help. That's exactly what Mr. Southwell tried to do. In the Kenai courthouse, he had me, he had Mr. Zellers, he had Mr. Angleton, Mr. Hildebrand, who didn't testify today, my wife. He had all the same witnesses lined up to do exactly to that grand jury what he did here for you. And he got shut down. In Minneapolis, a grand jury hired its own private detectives and amassed evidence sufficient to indict the mayor of Minneapolis and caused the chief of police to resign. After removing these officials, the grand jury acted as a committee of public safety and effectively governed the city. 5 years later in San Francisco, a grand jury indicted the mayor and named a new reform mayor to run the city. And like I said, this is what the Alaska Judicial Council put out about the authority of the grand jury. I'm going to go over now what some of the founding fathers of Alaska's Constitution stated about the grand jury. An amendment was proposed to make prosecution by grand jury indictment mandatory unless waived, as had been the practice under territorial law. Proponents of the change in the committee proposal argued that the grand jury was not the best charging mechanism. All delegates, however, appear to have supported the continuation of the investigative role of the grand jury. And I'm just going to go over what some of the delegates to Alaska's Constitution said. We have preserved the investigative power of the grand jury. That was Buckaloo in the report. Sometimes, the grand jury is useful where any particular fraud or general scandal has occurred. Rivers. And that's what we're talking about. Scout leaders and troopers and judges all manipulating the system against the public. And so the founding fathers of Alaska's Constitution specifically said that the grand jury is there to combat that. Another one said, I am against the use of a grand jury in criminal prosecution. In other words, this delegate to Alaska's Constitutional Convention says, we don't want the grand jury to be there for scout leaders. But he says, I would say retain the grand jury all right for investigative purposes of officials in public institutions. It serves no useful purpose except for just investigative purposes. So I'm telling you that I'm going to just, any one of you who knows somebody on the grand jury, you just tell them, hey, close the door in the face of scout leaders and the troopers.
Is there a list to find out who's on the grand jury?
The grand jury is supposed to be secret, so you're going to find out about by friends talking to you. I think we could go in there. I'll just keep going over here, but that is a good question. You can't. Grand jurors are supposed to be kept secret so that people that they're investigating and thinking about indicting can't find out who they are and then put pressure on them to say, hey, if you indict me, your family's at risk or whatever, or so that, people don't know who's being investigated. They may flee the country or any number of things. But anyway, I'm going to just bomb through here. Another delegate said, delegate speaking suggested returning the language in the initial committee proposal that referred to the grand jury's investigative powers. This is what they're talking about. The first thing that was going to be in Alaska's Constitution, they had wrote down this: the power of grand juries to inquire into the willful misconduct in office of public officers and to find indictments in connection therewith shall never be suspended. That was then changed. They say when the subject of investigative powers arose again, the proposed language was somewhat different. The new suggested language read, the power of grand juries to investigate and make recommendations concerning conditions detrimental to the public welfare or safety shall never be suspended. And if you remember, they changed that just slightly, one word, to where now in Alaska's Constitution, Article 1, Section 8, concerning the grand jury, the last line says, the power of grand juries to investigate and make recommendations